Welcome to Literary and Jury Charge Practice. Let's start out with this short jury charge. Ready? Here we go. Okay, members of the jury, what I'm about to say to you is a brief general introduction of this trial so that you'll be better able to perform your important duty of deciding the facts diligently and conscientiously. If they wish, attorneys may make opening statements. Opening statements are not evidence. They're only statements of what the attorneys expect to prove. At times during the trial, objections will be made, and I will rule upon them. You should not concern yourself with the objections made by the attorneys or with my ruling on those objections. During the trial and during any recess, do not express any opinion about the case. Do not even discuss the case either among yourselves or with any other person. Do not allow yourself to overhear anyone discussing the case. Do not have any contact outside the courtroom with any of the parties, witnesses, or attorneys. Do not research or investigate the case on your own. You must base your decision only on the evidence presented in this courtroom. Keep an open mind throughout the case, throughout the trial. At the end of all the evidence, I'll explain to you the law that applies to this case. Now we've given you each a notepad and pencil. You're free to make whatever notes you deem appropriate. I would caution you, however, not to let your note-taking interfere with listening to the evidence. Now, as I mentioned previously, we only have one issue here on liability. We're not here on any monetary damages. Additionally, the parties have entered into several stipulations. That means which will be read to you in a minute. That means they have agreed that those facts exist and you should consider them proven. Right. That was a short one, huh? All right. Next, let's try this closing argument. Ready? Here we go. Madam Forelady and ladies and gentlemen, I'm just going to take a very brief time. You've heard lawyers say this, I'm sure, but I will be brief. There are 2 pages on your verdict sheet, and I respectfully suggest to you that the very first question has to do with my client, Cindy Young, and that your answer should be a quick no. She was not negligent. She did not cause this accident. Let me take a moment to tell you that what you just heard from plaintiff's counsel is interesting because he is saying that Baltimore Tank Lines, through its operator, should be responsible for this accident for 2 reasons. 1, the operator of that truck abruptly changed lanes right in front of Mr. Irvin without a signal and caused an accident. It's interesting to note that that same scenario that he describes as being the basis for his claim against Baltimore Tank Lines is exactly what Mr. Irvins did so far as my client is concerned. He abruptly changed lanes right into her path without a signal, without applying his brakes, without a horn. Why? I can't answer the why. Mr. Irvins has given you an explanation as to why he did it, but the fact is he did it. Was he forced over? I can't answer that question. That is his contention. My client did not see the tanker truck. She can't tell you whether he was forced over and why he went over. But the fact remains that Mr. Irvin came directly into the path of my client's car, and as he said, within a split second was hit. There is no proof that my client did anything wrong. She's driving home from the doctor's visit with her 6-year-old child when all of a sudden, for whatever reason, Mr. Irvin comes into her lane. There is nothing she could do. Plaintiff's counsel suggested to you that maybe you could conclude that there was something else she could have done to avoid this accident, and I suggest to you would the right thing for her to do to veer over into what would be the opposite lane of traffic as Mr. Irvins veered into her lane. I respectfully suggest to you that would not be the right thing to do. Ms. Young tried to get stopped, but couldn't through no fault of her own. Whatever you decide as to why Mr. Irvins came over into that lane, whether it was because he was forced over, as he said, or for some other reason, I suggest to you that has nothing to do with my client. The fact is, he came right into the path of her car. She should be held not negligent, and I respectfully ask that you answer no. Thank you. Right. Let's see. We'll try some literary material now. This is called Seaside Circuit. It's about the iconic Long Beach Grand Prix. Ready? Here we go. 3 ways you can tell spring has come to Southern California. The Swallows return to Capistrano, the Dodgers return to Chavez Ravine to play baseball, and the sounds of roaring engines return to Long Beach as America's longest running street race gets underway. For more than 40 years, drivers in the Toyota Grand Prix of Long Beach have descended on this port city to race around its oceanfront streets, nowadays weaving past the Convention Center, the Long Beach Arena, and the Aquarium of the Pacific. Onlookers standing on balconies of nearby apartment towers crane their necks to catch a glimpse of racing's elite as they twist through the palm tree-lined course. The annual event has helped revitalize the city's core and has carved out a significant place in racing history. Besides Indy, this is the place You want to be in the winner's circle, says driver Helio Castroneves, 3-time champion at the Indianapolis 500 and the winner here in 2001. It's certainly the place to be for high stakes drama on race weekend, but plenty of action also takes place behind the scenes. For 9 weeks before the race, workers labor to transform the streets into a motor racing mecca. They start in February. A full-time staff of 6 and a crew of about 24 workers assemble the race course, build grandstands, and make sure all the food vendors and race teams have what they need, all in about 60 days. That may sound like a long time, but the team is also constantly shifting to and fro to keep access available to a busy convention center and arena. It's a dance they've had 4 decades to perfect. The race is the brainchild of Chris Pook, a Long Beach travel agent who dreamed of bringing Europe's Formula One racing to his hometown. That vision dovetailed nicely with city officials' desire to change the image of an aging downtown. Pook staged the first Long Beach Grand Prix in 1975 as a Formula 5000 race and followed 6 months later with a Formula One race. The format has changed through the years, but the event has featured Indy-style cars since 1984. That first race in 1975 marked the debut of a key safety innovation, concrete barriers topped with rigid fencing. Before then, bales of hay were used to protect spectators. In 1952, a tragic accident at Watkins Glen in New York made people think twice about opening city streets to road racing. A car swerved into the crowd, killing a 7-year-old boy and injuring 10 others. The incident had a dramatic effect on racing in America, highlighting spectators' vulnerability. Street races couldn't get insurance. For 2 decades, racing fans had no choice but to visit permanent courses that often were located well away from cities. Enter Dr. Peter Talbot, a Menlo Park obstetrician turned race car driver. He came up with the concrete barrier idea, which the Long Beach race organizers put into practice. The barriers have since proved a great success, with not a single spectator fatality in the race's history. All right, let's get back to some more closing arguments. Ready? Here we go. Ladies and gentlemen of the jury, there are certain exhibits that have been admitted into evidence, and I'm holding them here. Defendant's exhibits have been marked BTL in various letters, and you'll be having the opportunity to take these back with you and to review these in conjunction with your deliberations. And these are all scaled engineering drawings prepared by an engineer, including scales drawings of the vehicles, and you'll note the scale is at the bottom of the pictures. I just want you to note that, and you'll note the A, B, C, D, which are broken down. If you look at the scale section, you'll see the letters that you can interpret that. I just bring all that to your attention. And a lot of the pictures don't have any pictures of trucks on them, and then some of them do. And these are the exhibits G, N, O, and H. And these are the exhibits that Mr. Quaid testified to that are representative of his usual practice. How he travels down Mattawoman Beantown Road and changes into the turn lane. That's what he testified to. Now, in conjunction with the plaintiff's case, if you are to believe Mr. Irvin's version of events, you must accept and believe that Mr. Quaid failed to do what he does every single day. You must accept that he did something different than he usually does, because if he did on the date of this what he did every single day, there's no way the plaintiff, who was traveling behind the tanker trailer, could have gotten around and he changed lanes into him as he described. It couldn't have happened, so it's physically impossible. So you must accept, for some reason or another, Mr. Quaid just didn't do what he usually does. You must also accept, if you are going to accept the plaintiff's version of events, that Mr. Quaid did something which was totally counterintuitive. Instead of just filtering straight into the left turn lane, the right left turn lane, straight shot, straight in there, instead of doing that, you'd have to accept that he said, I'm going to make life difficult for myself today. I'm not going to filter straight into that left turn lane. I'm going to stay on this side of the dividing line. I'm going to travel down here on the through lane, on the left through lane. I'm not going to bother filtering. I'm just going to change lanes somewhere down the line, make life difficult for myself. It's completely counterintuitive. Moreover, he would have had to have steered to the right to avoid the merge. The merge is just a straight shot. You come straight down into it. It doesn't make any sense. So I would respectfully submit to you that his testimony was very important and is very significant in this case. It's his routine behavior. Moreover, after that, you have the testimony of Ms. Young, who testified, I didn't pull it out of her. It just came out of her when she said, you think I would have seen the tanker truck. She volunteered that during her testimony. It's exactly my point. You think she would have seen. I just, to make something very clear in case I didn't make this clear in opening statement, we are not pointing our finger at Ms. Young. We're not pointing our finger at, I'm not suggesting that she's done anything wrong in this case. We're not suggesting that she's at fault in this case. We're not adverse to her in this case. I'm not suggesting that at all. You heard her testify. You think I would have seen the tanker trailer, and yes, you certainly would have, because the only way that Mr. Irvin could have gotten to where he said he was when the tractor trailer began to enter his lane is from the position of being behind him, as if he came up and came around the left side of the tractor trailer. and that raised a very interesting point in his testimony. They presented this diagram here, which everyone else testified as completely inconsistent with their normal approach here and not consistent with Ms. Young's testimony. And now we find out it's not even consistent with Mr. Irvin's testimony. I asked him specifically, where were you in conjunction with the tractor and tanker trailer when it commenced to enter your lane? He said at the rear tandems. He never progressed any further forward than the rear tandem wheels. He was behind it. He came up around the inside of it, but he never got past the rear tandems. You see in this diagram, he's placed himself right up here beside the drive axles of the tractor. All right, we will stop there, and that will conclude our literary and jury charge practice.